State of Wisconsin versus Kevin Lychwick. Appearances are the same. Attorney Galloway is the standby counsel, is also in the courtroom. The court made just a few minor changes to the final jury instructions. Those all had to do with spacing and pagination. So there were no substantive changes. My plan is to provide 12 copies of the jury instructions to the jury. I figure having all of them with their own copy on this case might be a good idea. And the verdict forms, Madam Clerk, did you submit the previous verdict forms to the parties? Okay. I do have four verdict forms here. They read verdict as to count 1, then there's the not guilty and guilty, and verdict as to count 2, not guilty and guilty. So if either party wants to see those verdicts, they are welcome to, but otherwise the language mirrors what's in the jury instructions. I advised the parties just before we called the case that they are welcome to stand at counsel table. I offered a lapel mic to the state, which I believe they're going to utilize. Mr. Lychwick, you can decline the lapel mic if you want. I just want to make sure that my court reporter can hear you during your closing and make sure that the microphone picks you up. I really don't doubt that the microphone's going to continue to pick you up as long as the microphone's down on your table where it is right now and that you don't cover it with papers or anything like that. It should be fine. Anything else we need to take up before we bring the jury in? Attorney Thompson?
No, thank you.
Mr. Lychwick?
No, Your Honor.
Okay, let's bring the jury in.
For the jury.
Thank you. You may be seated. Ladies and gentlemen of the jury, I'll note that you all have entered the courtroom without your note-taking materials because the evidence portion of the case is over. We're now at the instruction phase where I'm going to instruct you on the principles of the law to guide you in your deliberations. Unlike the opening instructions, these ones will be provided to you for reference for your deliberations. In fact, I'm going to print off 12 copies of these so that each of you will have your own copy of the jury instructions. Despite the fact that you're going to be receiving a copy of these, I do urge that you pay close attention to the instructions of the law that I give you now, because they will help guide you as you listen to closing arguments as well. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts and the law. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count of this information in this case charges that the above-named defendant, on or about April 14th, 2024, in the area of 1512 East North Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Carlos Maldonado with intent to kill that person, contrary to Wisconsin Statute 940.01 sub 1 sub A. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The second count of the information charges that the above-named defendant, between April 14th, 2024 and October 30th, 2024, in the area of 1512 East North Street in the city of Waukesha, Waukesha County, Wisconsin, did hide a corpse with the intent to conceal a crime, contrary to Wisconsin Statute Section 940.11 sub 2. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. Standby counsel has been appointed by the court to assist with the efficient operation of the trial. The defendant, though, is still representing himself. The defendant has appeared at times in court wearing orange clothing. You must not infer anything from this. This must not influence your verdict in any manner. First-degree intentional homicide, as defined in 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant caused the death of Carlos Maldonado. Cause means that the defendant's act was a substantial factor in producing the death. Element number two, the defendant acted with the intent to kill Carlos Maldonado. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Carlos Maldonado with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Hiding or burying a corpse. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant hid a corpse. Element number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with a purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not establish evidence of guilt by itself. You should give it the weight you believe it deserves under all of the circumstances. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial, and whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement deserves. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. The court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence. An exhibit becomes evidence only when it is received by the court. An exhibit marked for identification and not received is not evidence. an exhibit received is evidence whether or not it goes to the jury room. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of the parties, the court is not indicating any opinion about the evidence. You, the jurors, are the sole judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the court itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony and remarks to be stricken. Disregard all stricken testimony. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining what the credibility of each witness and the weight you give to the testimony of each witness, consider the following factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason for giving the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. Ordinarily, a witness may testify only about facts. However, in this case, witnesses were allowed to give opinions based on their experiences. In determining the weight you give to this opinion, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based on that observation. Opinion evidence was received to help you reach a conclusion. However, you are not bound by the opinion of any witness. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. We will now hear the closing arguments of the parties. Because the state bears the burden of proof in this case, the state is allowed to go first and also make a rebuttal closing if they so choose. Attorney Thompson, you may proceed.
Thank you, Judge. Oh, wow, that's really loud. Okay, good afternoon, everyone. Thank you so much for your patience over these last few days. There's been a lot presented to you, and you are here to perform your civic duty, and we very much appreciate it. We're here this week because of Carlos Maldonado, and we're here to find out and prove to you who killed him. And now at the close of our case, the state has proven to you that Mr. Maldonado was killed by Mr. Lychwick, the defendant. As you heard from the court, the two elements of first-degree intentional homicide are that the defendant caused the death of Mr. Maldonado, and he acted with intent to kill him. We also have an intent element in the second charge of hiding a corpse. So instead of repeating the evidence for both charges, my intent here with closings is to argue how all of these pieces fit together for both charges. First, when we consider intent, as the court said, you can't look into a person's mind, and that's fine. So what do we have here in front of us? Operation Slop Shop. We have dates on exhibit number 146, and it says targets identified. It goes back to November of 2023, and interestingly enough, when we look at those autofill sections on Mr. Lychwick's cell phone, that's when you start seeing Mr. Maldonado's name. And those autofills don't just happen. That is the user who has to manually input those names, and then the phone remembers it. Then we have him on exhibit 146 as the target of the first operation. And the numbering of all four of these operations is very important, because when you look at exhibit 147, which is Operation Starling, it says at the bottom, the operation can commence since Operation Slop Shop is completed. Funds and reparations have been seized from Slop Shop, so for Starling, and all threats from the first operation have been neutralized. That first operation is Carlos. Now, how do we know that this note was written by Mr. Lychwick? When we look at all of the pieces surrounding this note, and even some of the context and additional items in there, we know that it belongs to Mr. Lychwick. So number one, it's found in his apartment. That's a really good place to start. He lives alone. He references his brother and his mother. He is next door neighbors with Mr. Maldonado. And think about all those German references. Absolutely fine to enjoy German history, to want to go visit it. That in and of itself is not criminal. But the whole point of playing those clips and showing you those conversations is to provide context and show that these notes belong to Mr. Lychwick, and they were written by him. There's another name in Exhibit 146 that we have referenced several times of Raven. The sole reason that the state provided the information and the phone searches and the Google returns about Raven is to connect Mr. Lychwick again to these notes. That is the sole reason. When we look at intent to kill and intent to conceal a body, we're also looking at the medical evidence here. And we heard Dr. Scheel talk all about how they processed this scene, how they brought Mr. Maldonado back, and why they did those x-rays. And her words were very specific. When we have a concealed body, we need to be careful on how we process and examine. And when they do those first set of x-rays, that's when we see the two projectiles, which we'll talk about in a little bit. But Dr. Scheel determined that the cause and manner of death was homicidal violence by the two gunshot wounds, and his manner of death was homicide. We may not know how far away Mr. Lychwick was standing from Mr. Maldonado when he shot him. We may not know which gunshot wound came first. But what we do know is that is the epitome of intent to kill. Because that is 2 times you have to pull that trigger. 2 deliberate times. And when we consider the trajectory that Dr. Scheel and Dr. Truesdale talked about when they used that probe, both trajectories of those gunshot wounds were in the right, up, and out the left. Almost as if they came in quick succession to have such a close trajectory to each other. Regardless, though, that's 2 times. We also have evidence that these gunshot wounds are front to back. So Mr. Lychwick is standing right in front of Mr. Maldonado. And let's not forget about the fact that Mr. Maldonado was shot in the face. That is deeply personal. That is intent. That is, I am removing this human being from this earth. That is the target. And that is a surefire way to kill someone by shooting them right in the face. We also heard from Dr. Truesdale about how there were other fracture lines on Mr. Maldonado's skull, and she talked about how that comes from the energy of the bullet, and all that energy needs somewhere to go. When we talk about then how all the threats are neutralized, if that's not intent, I don't know what is. We also then consider the phone searches from Mr. Lychwick's cell phone that we recovered during the search warrant on November 26th. What's interesting here, and what kind of overlaps with the trail camera videos, is that search on April 21st of 2024, 7 days after Mr. Maldonado was murdered, and about 10 days before we see him on that trail cam. He's searching for carcass removal, disposal, how to dispose of spoiled food safely. Sure, it could be innocuous, I guess, but not when you consider everything in the totality. That timing is just too specific. The nature of those searches, the carcass, he's referring to Mr. Maldonado. That's what this evidence shows. Because at that point, he has Mr. Maldonado up on top of that hill in the area in which Moxie gave her trained final response. But this is an apartment complex. This is land that's shared by everybody. And eventually, he'll probably be discovered. And so now, a week later, we have this search of how to get rid of a carcass. And remember that DNR article had 3 options. You can either take it to a landfill, you can take it back to where the harvest originally occurred, or you can bury it. Mr. Lychwick goes a little bit out of order, but it does make sense when you think about the timeline that we've presented to you. So first, we have him on those trail cameras then, 10 days later, with all of his gear. He's got his shovel, he's got his boots, he's got the plastic sheeting, he's got that black packaging with him that looks very, very similar to all of these black garbage bags. And he is up there for 30 minutes where we don't see him anymore, from 12:41 a.m. to 1:10 a.m. And when we see the direction that he's walking, it's exactly the direction up that hill. Because then when you go off camera, you continue going up the hill, or you can divert to that footpath where we eventually found Mr. Maldonado. And there was a lot of talk about something on Mr. Lychwick's hip in that video. Detective Stern said, "I can't tell for sure what that is." And Mr. Lychwick posited that it is a flashlight. Let's go with that. Let's say it is a flashlight. It makes sense in a way, because as you're up there on the top of that clearing, knowing, okay, the DNR suggests that I need to bury a carcass, so I'm going to try digging, and I'm going to bring my shovel out there. There's no lights up there. So of course you need a flashlight to see where you're digging. But then he realizes this isn't going to work. And as Detective Stern talked about, the dirt up there, you can get down a little bit, but then eventually you're hitting clay, you're hitting something harder. And that shovel that we have is not something that's going to be able to break through that. He can't bury Carlos deep enough to avoid detection. So then what does he do? Landfill. That's what we're going to do with this. So he starts dragging him down, because it's a lot easier to go down that hill than it is to go up that hill. So between that and Moxie hitting up there, that's where this all started. So then as he decides, I need to get rid of Mr. Maldonado, I need to get him off of this property, he has him in these opaque black garbage bags, which we saw from the Google returns. He's got the tarp as well, which helps him drag or slide Mr. Maldonado down the hill to this footpath. The ropes, when you look at those ropes that were tied to the chair in Mr. Lychwick's apartment, and you put them side by side with those ropes recovered from Mr. Maldonado at autopsy, look at those patterns. Look and make that comparison, because those are the same kinds of ropes. Because he used what he had. And so even those knots, if you look at how those knots are on each of those 4 ropes, they look pretty close to those photos of the ropes from his apartment. And when we talk about intent to conceal, he's even threading those ropes through the grommets on the tarp. We have tape on Mr. Maldonado's hands. We have that black duct tape that is used to enclose Mr. Maldonado, to tie together or tape together those black plastic garbage bags. And then once he is in this footpath, and we saw a picture of Carlos, he's not a small guy. And so if it's too difficult to get him into a car to bring him to a landfill, I can't drag him back up the hill now, so he's going to have to stay here. And so then we start piling on all of those branches, all that debris, and he goes undetected. Family knows that Carlos isn't here, that he's missing, but nobody sees him anymore. After Home Depot on April 14th, we see from his phone records he comes back to 1512 East North, and then nothing. There's no movement. Nobody sees him again. That combined with what he's wearing on that Home Depot video, and that's what he's wearing when we find his remains, this all goes to establishing April 14th. And even going back to those trail cams, yes, we have that half-hour break, but we never see Mr. Lychwick come back with any of his tools or his gear until 4:39 a.m. that morning. He goes back and forth. We see him go to the garage, We see him walking back up in that direction. So that's 4 hours where he's out there and he's not exercising. That just doesn't make any sense compared to what we saw him bringing out there. So then we talked a lot about the search of Mr. Lychwick's vehicle. And before we get to that point, though, he goes to U-Haul. And that is out of the ordinary for what the detectives have been seeing in terms of his pattern of travel over the last few days. So as he starts traveling north, we follow him to a storage facility that he has no history of searching for until within 48 hours of us finding Mr. Maldonado. He had rented it, according to that receipt, on November 1st, gets that free month promotion, and now he's got to empty everything out because that month is, maybe he's moving it. Maybe he's going to another storage unit. I don't know. But what we know is he emptied it. And then we follow him. And we saw him on the surveillance emptying it. So we follow him back to Waukesha. Officers stop the car. They seize the car. There's nobody else in the car with him. And what do we find after we get a warrant to search his car? The murder weapon. Inside that trunk, we find the shovel. In the back passenger seat, we have boots. We have numerous boxes of 9mm ammunition. So for Mr. Lychwick to say, I've never seen that gun before, I don't know what it is, I don't know how it got there. You certainly have a lot of ammunition for a 9mm. So then we also find all these garbage bags. We start putting all of these pieces together here. What's important to know, and really I'll sum up Ms. Crawford's testimony. She told us all about firearms identification and how we have those striations and those grooves and the manufacturing characteristics versus the individual characteristics. But here's the bottom line. These two projectiles recovered from Mr. Maldonado's body were fired from this gun, period. End of story. So now you have an individual who is targeting the victim. He has his name written in notes. He is up in a trail area at the top of the hill. He is hiding evidence related to a homicide. And you heard on that recording, they were tearing up everyone's apartments and I had to get my war bags out of there. Your war bags with the murder weapon? Thank you very much. So now we have this, and Ms. Crawford says, yep, this is the murder weapon. Now we go and arrest Mr. Lychwick. We get his buccal swab, which you've heard a lot about. And this is another reason why this whole theory of, I've never seen this gun before, I don't know anything about it. His DNA is all over that gun. When we heard from Ms. Taylor, we talked about the swabs from the grip of the Luger. And it's, in the state's view, important because this is a single source profile. There is no mixture. There is nobody else's DNA from the swab of the grip of this Luger. And it's Mr. Lychwick. And you heard Ms. Taylor talk about how in order to find another profile, or it would take us testing a quadrillion people to see a similar profile. There are not a quadrillion number of people in the world. So there's no question that Mr. Lychwick's DNA is on the grip of this Luger. Then we also look at the towels and the rubber bands. The exterior towel is a mixture, but we have very strong support for inclusion, which is the highest reporting level that our state crime lab has. We also see that quadrillion number again. And then we get to the interior towel, which is back to a single source profile. And it's Mr. Lychwick's. So, ladies and gentlemen, sometimes, and you heard Mr. Lychwick talking about it, objecting to it, sometimes little things, they might seem, well, everyone has bleach. Everyone shops for hand soap. Everyone shops for garbage bags. True. I don't dispute that at all. But you can't take everything and just look at it individually in a vacuum. Your role here is to search for the truth, not to search for doubt. And the truth is that on April 14th of 2024, Mr. Lychwick murdered Mr. Maldonado. And all of the evidence is right here in front of you. And so I'm asking you, when you go back there to deliberate, that you hold Mr. Lychwick accountable and you find him guilty on both counts. Thank you.
Thank you, Attorney Thompson. Mr. Lychwick, you may give your closing argument. You may stand at council table if you would like, and you can also use the lapel microphone if you want.
I think this microphone will suffice, Your Honor.
Go ahead then.
Ladies and gentlemen of the jury, thank you for coming and giving your precious time and effort to this case. I ask you now to do what you must do to acquit me of these horrible charges. I am totally innocent of this crime. I did not know this man well enough to hurt him. He did not know me well enough to have attempted to hurt me in any way. We were neighbors, but we did not know each other. The defense argues that I went on top of the hill. They take broad liberties with the truth and with their idea of facts in this case. But the fact is they have no proof that I was ever even on top of that hill. I have established that I have a right to be out in my own yard and do whatever I do. They have no proof that I even spent all the time they're saying I did on the night in question when they're insinuating that I had something to do with the handling of poor Mr. Maldonado. They don't know that I went home and that I was on a hike looking around for possums that lived in my yard and feeding my rabbits because I couldn't sleep that night, that I normally would put my tools down and go for a run up and down the hill or a quick trip to buy groceries at all hours of the day. During the daylight hours, I use a jogging suit. At night, if I'm out in my
I'm going to object at this point. This is all testimony and none of these facts are in evidence.
That's sustained. Mr. Lychwick, I caution you, you can argue inferences and argue what the state doesn't show in their evidence, but you can't testify about matters that have not been testified about. So just be careful that you're not trying to introduce new evidence or testify in any way. You can continue.
Ladies and gentlemen of the jury, as you were instructed to do so, I implore you, if you have any doubts in this matter, to find me not guilty. There are plenty of doubts in this case and what the prosecution has established as their case against me. The accusers, the Waukesha Police Department, headed by the investigative team of Detectives Benjamin Stern here. I implore you to weigh in consideration of my innocence in this matter and to take into consideration the manner in which they executed their search warrant against me. The search warrant being established originally because one of their detectives asked me, I think this has been established as evidence already, asked me about the presence of plastic bags in front of my car, in which I truthfully answered the detective, telling the detective that I moved my shovel and everything into my car for winter.
None of this is in evidence.
It has to be.
It's sustained. It's not in the trial record. The jury has not heard any evidence of this, and the legality of the search warrants and the manner of their execution is not an issue for the jury to determine. You can continue, Mr. Lychwick.
If I may, ladies and gentlemen of the jury, I have been unable to present a hearty defense in this matter because I have been imprisoned in the Waukesha County Jail for 18 months now and isolated from my funds and my family and my friends and my
Judge, I'm
ability
going
to
to
hire an
object.
attorney.
Okay, Mr. Lychwick, stop, please. Again, these are not matters for the jury to consider. They are to consider only the facts and evidence that was presented in the case, not what could have been, not what wasn't, only the facts and evidence that have been presented. Your status during the pendency of this case is not relevant and should not be matters for the jury to know.
But
You
Your Honor,
introduced it, but it should not be for them to know. So focus on the issues here and the evidence that has been received in the trial this week, and you can continue your arguments.
Your Honor, you noted these protests throughout the trial that
I have. Now continue.
Ladies and gentlemen of the jury, I implore you again, if you have any doubts as to my guilt, please find me innocent. I have a life out there. I am a good man. I am a God-fearing Christian. I just want to go home. I want to resume my life. And when I go home, the Waukesha Police Department and anyone assisting them will be able to continue searching for the actual killer or killers of the poor victim in this matter. As long as I am in custody, they have stopped looking for who actually killed this man. Imagine that whoever did this is still on the street. I implore you to please send me home. Find me not guilty in this matter because I am not guilty in this matter. And owing to the corruptibility of people and human nature, I am telling you there is a corrupt element within our local Waukesha Police Department. And if you find me innocent, perhaps there will be some house cleaning and they can take care of it. Somebody will investigate this matter and we will all be a little safer. I thank you for your time in coming here again. And again, my final statement to you is, if you have any doubts in this matter, if you have any doubts about my guilt, please find me not guilty.
Thank you,
I
Mr.
rest my
Lychwick.
case.
Any rebuttal closing, Attorney Thompson?
Very briefly.
Go ahead.
What I'd like to posit to the jury is there's probably someone else who really wants to go home or wanted to go back to his apartment that night.
I object, Your Honor. She's already had her chance to make her statement in this matter.
The objection is overruled because the state bears the burden of proof in this case. It is allowed by law to give a closing argument and provide a rebuttal closing. So the state gets the last word. Attorney Thompson, you may continue.
Thank you. Mr. Maldonado had plans with his daughter, and she never anticipated that he wasn't coming back to his apartment that night. And so who's responsible for that? Mr. Lychwick. So let's all remember why we are here. Because Mr. Lychwick murdered Mr. Maldonado. And that's what this evidence shows. And the law that the judge read you is not, if you have any doubt, you're not searching for doubt. You search for the truth. And the standard is not beyond all doubt. It is
Objection,
beyond.
Your Honor.
What's your
She's trying
objection?
to instruct the jury to find me guilty.
I disagree, Mr. Lychwick. The state is reciting elements of the reasonable doubt instruction. That's permissible. And ultimately, ladies and gentlemen, you are bound to follow the law and the instructions I give you, not the law and the instructions the attorneys may interpret or recite. Ultimately, what's in the jury instructions is what you follow. Attorney Thompson, you may continue.
Thank you. As I said, it's not any doubt. It's not even beyond all doubt. It is beyond a reasonable doubt. When you look at all of these pieces together, just like Dr. Truesdale said, the bones tell a story. They tell a story about someone's life. And all of these pieces of evidence here tell us the story of how Mr. Lychwick murdered Mr. Maldonado and then hid his body so that nobody would find him and hopefully he would get away with what he did. So I'm asking you to find him guilty on both counts. Thank you.
Thank you. Now, members of the jury, the duties of the parties in the court have been performed. This case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 4 forms of verdict will be submitted to you concerning the charges against the defendant, Kevin Lychwick. As to count 1, one verdict reading, we, the jury, find the defendant, Kevin W. Lychwick, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we, the jury, find the defendant, Kevin W. Lychwick, guilty of first-degree intentional homicide as charged in count 1 of the information. As to count 2, 2 verdicts. One reading, we, the jury, find the defendant, Kevin W. Lychwick, not guilty of hiding a corpse as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Kevin W. Lychwick, guilty of hiding a corpse as charged in count 2 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case, and therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any question in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. We will first swear the officer and then strike the alternates.
Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them, or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I do. Ladies and gentlemen, there are 14 of you, and we can only allow 12 to go back and deliberate on this case, which means we must strike 2 jurors at this time from the jury pool. Those alternates are picked by random. It's probably disappointing if you get selected as an alternate because you've sat through all of this trial and you can't participate. But understand that we pick alternates the way we do just to guarantee that if any emergency comes up or we lose a juror for a family emergency or a medical situation, that we can continue the trial. So we build in a little bit of a buffer to allow for that to happen, especially on multi-day trials. So I have the list here with the alternates. If I read your name as an alternate, I ask that you stand, please. The alternate jurors are Paige Hornack and Nancy Kovacs. Okay, what we're going to do is Our jury bailiff will escort you back to the jury room to get any belongings that you may have back there. I'm going to ask the other jurors to remain where they are for now. We'll have those jurors go collect their materials, then they can be released. And once that's done, we'll have the other jurors retire to the jury room.
There is, if you can wait, I can get it to her. Thank you.
I'm now providing a copy of the verdict forms and 12 copies of the jury instructions to the jury bailiff, and the jury may now retire and begin their deliberations.
All rise for the jury.
Thank you. You may be seated. We are now outside the presence of the jury. If the jury requests any of the photographs that were used and published, my inclination would be to provide those to the jury without calling the parties back to go through each one that they've selected. Mr. Lychwick, I recognize that you've objected to a number of the exhibits being introduced. The exhibits that have been introduced and already used with the jury, I would send those back if they request. Do you have any issue with that process?
I certainly do, Your Honor. Especially if I entered a prior objection to them.
And your objection would still be noted to those exhibits, but my point is that they've already been shown to the jury. So if the jury asks a question, I would have to bring you back into the courtroom. I'd have to bring the state's attorneys back. We would confer about the question, provide an answer to the jury. Sometimes that takes a little bit of time, and that's what we will do for ordinary questions. Other times the jury says, hey, could I see exhibits 120 through 130? If those are all photographs that have already been displayed to the jury on the screen, I'm not going to bring the parties back and talk about whether or not those should go back to the jury because they've already been displayed in court. The jury has already seen those. They're just asking to see them again. For photographs, I'm just going to send those back to the jury. For other things where parts of them may have been published, for example, some of the reports were published but not in their entirety, I would not be sending those back automatically. We could discuss that. But I'm just talking about just regular pictures, one-page picture files. If the jury asks for those, I'm going to send them back without bringing the parties in to talk about that if they've already been published. Understand?
I think so, Your Honor.
Okay, that's fine. And I was going to go to the state. Attorney Thompson, that's fine with you?
Yes, I'm sorry.
That's fine. If there's anything else where I see they've requested another exhibit that may have been published in part or something other than just a simple photo, I'll call the parties back. Then with the issue of the videos, if they request to see any of the videos, we do have the capability of streaming the videos directly back into the jury room. We can either do it one of two ways. We can stream it back in the jury room, or we can bring them back into court and play it again on these monitors. I'm going to decide to stream the videos into the jury room. The way we do that is we have one of our bailiffs go back to verify that the streaming and the live feed is live. We will play the videos twice, and then that'll be the extent of how they're played back. Because we can't just send a thumb drive and the videos back to the jury and let them poke around with the videos. We have to control the playback. So that would be the process for the videos. If there's any other questions or any other exhibits that they want to see that don't meet those, well, sorry, let me just be clear. If we live stream the videos, I'm calling the parties back, and we'll reconvene. We'll do it on the record. We just won't have the jury brought in. But otherwise, simple request to see the photographs. I'm not going to bring the parties back to do that. Anything else from the state then before we wait for deliberations?
No, thank you.
Anything else from you, Mr. Lychwick?
Well, thank you, Your Honor.
Okay, then the state, please provide some contact information, and we will stand in recess until we have a verdict.